to 5. 5 to 5, I'll see you.
You know, like you have problems of hearing, I must get an aid. Does it work?
I do. I've made it a बहुत साल हो गए.
Huh?
बहुत साल हो गए.
Vohra sahab, shall we start?
Just lost hearing.
Shall we start?
पता नहीं कहीं जाना चाहिए मुझे. Scribbled notes, they
But
don't
you
matter.
don't seem to have a problem.
I do. I asked Vohra Saab some questions about the Vohra committee.
Good evening, Mr. N.N. Vohra, a life trustee, distinguished members of the panel, distinguished members of the IIC and trustees, and ladies and gentlemen, friends. It's a pleasure to meet on this eve of the 75th anniversary of the Constitution and the Republic to discuss and to celebrate a milestone and an achievement with all its warts. And I think we are privileged to have today a very distinguished panel about which I will say more later. What I wanted to do in these few minutes was to give you the background of how this evening's discussion was conceived. The IIC has a program on federal democracy, which is now in its second year, where we have been meeting and discussing different dimensions of India's federal democracy. I, along with my colleagues, many of whom are here, as we are a team of 6 or 7, and now we jointly run this program. And the idea, the basic idea behind it, is to look at the way in which one can consider beyond the original intergovernmental relations framework, the relationship between federalism and democracy. So getting away from institutional determinism and looking at this triangle of constitutionality, legality, and legitimacy. And one could say that federalism imparts a certain amount of legitimacy to the system that has evolved. I would put before you 3 propositions for your consideration and for the consideration of the distinguished panel which is going to take up the issues. The first is the federal construct, the idea that federalism is a central fact of the republic as it was designed. It has all the critical attributes, the classical ones I need hardly mention, a written constitution, division of powers clearly stated, and a judiciary to arbitrate differences. It has been critiqued and it can be critiqued for the way in which the powers are distributed. And of late, it's the concurrent list which is becoming the villain of the piece. But there is a slow recognition that it is an integral element of the basic structure, not a model, but certainly a variant of the genus or the species. The second point that flows from this is the integrity of institutions and the fear of the suborning of institutions of the federal state. Suborn, as you know, is to induce secretly to do an unlawful thing. The process of suborning institutions hits at the core of the whole edifice that has been so carefully built up. And the distribution of powers is subverted, or institutions are deactivated. All this is part of the process. The extent of undermining state institutions, which are designed to remain distinct and detached from governments, therefore designed as state institutions, is the corollary at times, or the linked phenomenon that we see. The second proposition that I am placing before you, given that we are looking at India, the Indian Republic and Constitution in its 75th year, the second proposition is that how does one link up federal theory and democratic theory? The interface, the convergence, and the basic issues that one needs to keep in mind when one is looking at this linkage. And very often these two theories are talking past each other and far too long. Here the proposition that I am placing before you is that unity without uniformity is the key to a more perfect union. The effort being to strive for a more perfect union. And therefore, the pure majoritarianism variant of democratic theory is incompatible with federalism. Pure majoritarianism and federalism can't coexist because it is a violation of basic federal principles. So, overwhelming consensus also we find is that the integrationist and assimilationist approach negates and violates the rights of minorities to exist as such, and this is linked again to the question of pure majoritarianism. The third proposition that I am submitting as part of this perspective on federal democracy is that federalism defines democracy in a system that we have been accustomed to. It defines democracy because it defines government-opposition relations. There is a duality of government-opposition relations, one in the Union Parliament and in the second in state legislatures. And split mandate is very much of the essence of this arrangement. Therefore, the attempts to merge these two mandates through a single election makes a nonsense of the whole idea of distinct mandates and separation of elections. There is a resistance that emerges in the different levels of the federal system, which is very much a part of the design. Finally, the third issue that I wanted to place here, that we could look in our thinking on the cultures of governance and tolerance, on the significance of fraternity, the third of the rallying cries of the French Revolution, and which is incorporated in the preamble. Fraternity was what emerged when feudal vassals sought to create other bonds, alternative bonds, and that was through citizenship. Unlike liberty and equality, there are no laws to codify or enforce fraternity. It can't be legislated. The closest value is found in solidarity, which has been expressed most recently, we heard, by Bishop Budd. In French jurisprudence, interestingly, there is the notion of a crime of solidarity. No, sorry, not a crime, an offense of solidarity. Offense of solidarity is an extenuating factor when, for example, you give shelter to an illegal migrant. You have committed an offense technically, but it is because of the solidarity that you displayed, and jurisprudence recognizes that. So therefore, to conclude, three propositions that I would again sum up. One is that federalism has imparted resilience to Indian democracy. The second is that majoritarian democracy is incompatible with the federal principle. And the third, that unity without uniformity is attached to the motto of unity in diversity. So with that, I request Chair, Mr. Vohra, to come up and welcome us all to this gathering. And may I request you to please put your cell phones on silent mode. Thank you.
Since I left the academy a long time ago, I've become very irreverent.
I have the pleasure and the honor of introducing the panel that you are going to be listening to today. Justice Madan Lokur served as a judge of the Supreme Court of India from 2012 to 2018. During his long and illustrious career, he built a legacy of impartiality, intellectual rigor, and progressive legal thinking. Post-retirement, Justice Lokur was appointed to the Supreme Court of Fiji's non-resident panel and has been recently appointed to as chairperson of the UN Internal Justice Council. After studying law at Delhi University, he practiced at the Delhi High Court before being appointed Additional Solicitor General of India and became a permanent judge in 2004 and was appointed to the Supreme Court in 2012. During his tenure in the Supreme Court, Justice Lokur became known for his keen understanding of constitutional law and his singular approach to issues concerning social justice. He was part of several landmark judgments, especially those related to human rights, the rights of marginalized communities, environmental concerns, and the protection of fundamental freedoms. He stood out for his sensitivity towards issues related to child welfare, environmental degradation, and judicial accountability, to the extent that his bench became known as the Social Justice Bench. Throughout his judgments, Justice Lokur has repeatedly emphasized the importance of justice and transparency for a vibrant democracy. He was a member of the National Human Rights Commission and has been vocal in his advocacy of reforms within the judicial system. He has also been actively involved in discussions on environmental issues, particularly related to pollution and its impact on public health. Please welcome Justice Lokur. The second panelist is Dr. Rajeev Dhavan, who is one of our foremost jurists and constitutional experts, a renowned human rights advocate with a distinguished career spanning several decades, known for his sharp intellect and unwavering commitment to justice. He has played a major role in shaping Indian constitutional law and advancing the cause of civil liberties. Rajeev Dhawan was born into a family of eminent academicians and studied law at the University of Allahabad before earning his master's degree from the University of Cambridge and his doctorate from London University. He subsequently taught at prestigious institutions abroad at the Queen's University of Belfast and the University of West London, to name only a couple. Dr. Dhawan has argued before the Supreme Court of India on several crucial issues, including freedom of speech, minority rights, secularism, and environmental law. He has pleaded in many high-profile cases, notably the Babri Masjid Ram Janambhoomi dispute, where he provided a strong defense for constitutional values and secular principles. Alongside his legal practice, Dr. Dhawan continues to be a prolific writer, contributing extensively to legal scholarship. His works address a wide range of topics, from the law of the press to censorship and intolerance. A 2-volume study of the Lokpal and is known also for his work on social justice and human rights. His lengthy introduction to Mark Galanter's classic Law and Society in Modern India, and his landmark, How Parliament Debated Reservations. Throughout his career, Dr. Dhawan has been a vocal critic of authoritarianism and an ardent supporter of democratic ideals and human rights. During his tenure at the International Commission of Jurists, he condemned the US invasion of Iraq, and his scholarly work makes him an inspirational figure in the Indian legal and socio-political landscape. Dr. Dhawan. The third panelist is Professor Neera Chandok, an old friend who's a distinguished scholar known for her extensive work in political theory, comparative politics, and the politics of developing societies. She served as professor in the Department of Political Science at the University of Delhi and was the director of the Developing Countries Research Center. Professor Chandok has held several prestigious fellowships and positions during her long and illustrious career, notably at the Center for the Study of Law and Governance at Jawaharlal Nehru University, at the Goethe University, Frankfurt, at the Center for Ethics and Global Politics in Rome, and the Center for Civil Society at the LSE. Her scholarly contributions encompass a range of topics, notably civil society, democracy, rights, secularism, and political violence. Notable publications are State and Civil Society, Beyond Secularism, The Rights of Religious Minorities, The Conceits of Civil Society, Contested Secessions, Democracy and Revolutionary Politics, Rethinking Pluralism, Secularism, Tolerance, and Violence in Our Bones. She has recently published a short introduction to the Constitution titled We the People. Professor Neera Chandok. I now call upon Vohra Sahib to
Good evening, ladies and gentlemen. Professor Arora has I've given you an extensive background of why and how we are assembled here this evening. And he has also posed a number of issues which could perhaps be happily focused upon by the distinguished panelists. I'm very happy to join Professor Vohra in welcoming Justice Lokur, Dr. Sethi, and Professor Chandok. Justice Lokur has, from time to time, whenever we have approached him for help, to be with us on a certain occasion, to chair an event or to speak on in a given program, he's always helped us, always there. In the COVID times, he was doing that online, and of late, he has made himself available whenever we have called upon him. Dr. Rajeev, Dhavan and I have known him for a long time. I was telling him a little while ago, in the early 90s and early years of the century. But after that, I went away in some other direction and he was lost in his own work. Very happy to see him once again after a considerable time. Professor Chandok is one of our distinguished, very distinguished members of our center. So are the other two, by the way. So is also Professor Balveer Arora. All four of them on the dais are our members. Professor Chandok is a prolific writer, analyst, and most of all, and more importantly, she writes frequently for the national media, and she's been writing for one of the newspapers with which I have been associated. I welcome all of them. Now, after what Professor Vohra has said in very succinct terms, I think anything I say would appear trite or irrelevant. But my entire background has been in the arena of public administration for more than 60 years. And I cannot help but refer to certain issues which keep bothering me and for which I have not found any answer so far. Notwithstanding the intellectual debates of federalism, democracy, how they correlate and how they don't correlate, and what we should be doing, if at all we should be doing anything, when majoritarianism seems to be overreaching the fundamentals of democracy. Now, governance, with which I have been basically associated, involved all these years, is felt more in easy terms with public administration or the functioning of the governmental machinery. It takes this, it is founded in the principles, articles of the Constitution, the directive principles of state policy, the rulings of the Supreme Court. All these over the last 75 years have contributed to the if I may say, so much the organizational structure of governance, but more to its direction and content. While the direction and content are, I think, quite indisputably laid out in the directive principles. But still, as time has passed and situations have changed, the apex court has given rulings, passed orders, which have brought clarity to certain matters which relate to policy formation. But government and governmental functioning, as understood by the definition of the Constitution, from flow from the Constitution, the executive, the political executive, the appointed executive, which works on behalf of the political executive, the legislature, which is elected, and judiciary, which is by itself and supreme. Now, over the years, I wonder, and that's the question I posed to Justice Lokur, if it is possible in the course of this evening for him to make some comments. Over the period of decades, we have seen, perhaps it had to happen, perhaps it is natural, perhaps I have not fully understood the contours of the situation. There has been deterioration in the functioning of the polity and in the executive, both the elected and the appointed elements. And the legislature has also declined. There was a time 65 years ago, 60 years ago, when I joined service in the late 50s. The legislature was supreme insofar as the executive was concerned. We were accountable to the functioning of the legislature. Questions were asked, issues were raised. There were committees of the legislature. We had to appear before them. We had to satisfy them. They recorded their findings in the form of reports, a public accounts committee, estimates committee, and so on. So government was on test all the time. And it was the legislature which was putting the executive to test. But over a period of time, all that is not happening. And ironically enough, all of us, I suppose you and all of us in the audience, depending upon which particular vocation a person comes from, we in the civil services, in the police services, in the foreign service, in the forest service, in the revenue, customs, whatever, we all take oaths of office. So do the parliamentarians, so do the MLAs in the state, so the chief ministers and the ministers in the center, the judges of the high courts, the chief justice of the high court, the judges of the Supreme Court and the chief justice, they all take oaths. And we owe allegiance to the Constitution, our fealty, our loyalty. And we in the civil services, the executive, the appointed executive, we also take oath to commit ourselves to do greatest good to the greatest numbers and never falter in our decision making. We decide things without fear or favor, without ill will, uphold the unity and integrity of the country, and protect and preserve the Constitution, and so on and so forth. All that is there in every principal vocation in the country, whether it's a state service or a union service. We are committed by oath, essentially to the Constitution and thereafter to other objectives and goals. Now, what has exactly gone wrong, and why has it gone wrong? That there is a decline, and Professor Arora is talking about the contrariness of certain things, the resistance of certain elements, and how we are going to match a certain tendencies and certain situations which are growing up in recent years. Now, as far as the functioning of the governmental machinery is concerned, I think it's a better example to talk about the states where the people live. What do they expect? They expect it's a welfare state. They expect the poor people particularly. They expect the alleviation of poverty, some opportunities for education, a shelter, clean water, employment opportunities, advancement in their careers, some prosperity within the families so that they can run happy families. Now, I will not go into excessive detail because of the time factor, but I dare say that in our population of over 1.4 billion, whatever be the debates in the Niti Yog or in the media or in the Economic Times, we do have a considerable percentage of our total population which is still poverty-stricken. Say 18%, say 20, 22, there are all kinds of definitions, the nutritional approach, the multidimensional approach, and so on. But I say out of 140 crore or 145 crore, we do have 20 to 30 crores poor people in the country. Now with the 75 years of, 78 years of freedom, 75 years of the Constitution, what is it that has failed particularly that we have not been able to catch up with the challenges of nation building with all the moral authority and the power and strength that is given to us by the Constitution? How is it that the institutions of governance, Professor Arora mentioned to that there is danger now to the threat is there to the subversion, sabotage, the subverting of institutions, constitutional institutions, statutory institutions. There's a whole large network of institutions which connect the whole country, states in the center, states in the union. Whether it's the CAG or the AGs in the states, whether the Union Public Service Commission and the state public service commissions, and so on, there is a certain conformity, a certain commonality of approach which brings us together in convergence of objectives. Now, how is it that we have not been able to amend our electoral laws, People's Representation Act, all these years? There are numerous reports of the law commissions which have not been so far implemented. Corruption is rampant, whether we like to admit or not admit, at the ground level, I'm saying. You may not see it in Delhi or around the Max Muller Bhavan, but corruption is there. And sadly, 40 to 50% of the parliamentarians who get elected, legislatures and state legislatures, they have criminal records or they have cases against them. And this is not. We've not been able to do anything. It was well established years ago, decades ago, that there is a criminal nexus between the political system and the bureaucratic system and the mafia. We have not been able to do much about it. Now we've been overtaken by drugs, by the importation of drugs, by the smuggling of drugs, by our adversary neighbors doing all kinds of activities which create problems for us. There is, first of all, there is the narcotics, then the narco-terrorism, pure and simple terrorism, all kinds of intrusions, subversions. So we are kept busy with an array of challenges and issues which face us. And I would conclude by a simple, it was not a question nor a pointer, as Professor Arora has very rightly in his wisdom pointed to the things on which we could speak about. I keep wondering, Justice Lokur, that once the executive has failed, wherever it has failed, in whatever manner it has failed, and the legislature has also failed, and it has patently failed, not performing its duties, how does the apex court react to these failures within the ambit of our constitutional framework? The Supreme Court is all supreme. It is totally independent. And is there any hesitation or a constraint of not striking on the nail when it is early enough to do that? Or does one have to wait indefinitely to see whether with the passage of time reform will take place and things will be normal once again? Because what has been happening in the long years of my own service and post-retirement, it may be perhaps my own personal mental problem or psychological problem that everybody who's getting old looks back and says that the days past were better than the present. But I do feel that in ethical terms and moral terms, in terms of our efficiency and performance, there has been a decline. We have larger systems now, better systems. We have enormous successes in the field of science and technology. Space, look at that, our satellites, our nuclear technologies, our space technologies, our information technologies. We are amongst the top in the world. And yet, we are pulled backwards by certain forces, by certain negativities, and not able to deal effectively with those. Is it all due to the failures of the polity? And because of the failures of the polity, the failures of the bureaucracy and the entire administrative system? Or is it that somewhere or the other, the judiciary has not struck the nail on the head? Thank you very much.
My moment has come.
Yeah. Request Dr. Dhavan to please address the gathering.
This is my third public engagement in 20 years. I'm nervous. But let me begin by talking of the panel first. Mr. Vohra is a statesman civil servant. He knows more about the state and, more importantly, the deep state. Remember, what is important for us to know is the deep state. All of us only know the state on a how-to-know basis. We do not know the deep state. And unless we understand it, and unless Mr. Vohra discloses it, we will never know. Madan is a very distinguished jurist. For those who talk of federalism, read his judgment on Arunachal. It is a gift of restraint and precision. But the most important judgment of Madan's is in Abhiram. Abhiram raised the question, can appeals to religion be made or not? The majority in 7 judges said, led by Madan, it cannot be made. Guess who the minority of 3 judges were? Chandrachud, Lalit, Goyal. There is much to be learned from Madan, and even though he has retired, I tell the other panelists, as I said earlier, get into judicial discourse. Indira, of course, is very well known, and I want to read more of her work. She explains the working of our constitutional dilemmas. But leave that aside. I want to address one and only one question today, and I will elaborate. We live today at the time of an elected dictatorship. It's very important to recognize that we live in a time of elected dictatorship. What elected dictatorship does is destroys federalism, it destroys human rights, it destroys democracy. Now, I am not concerned with the mad emperor in the White House, who also is an elected dictator. I am concerned only with the impact of elected dictatorship in India in constitutional terms. What does an elected dictatorship do? To my mind, there is one underlying cement or process in the Constitution. That is the system of checks and balances. I see a very distinguished man sitting there who may have some things to say, but anyway, leave that. Now, what does checks and balances do? To the executive, it says you are responsible to Parliament. To Parliament, it says you are responsible to the people. There has been such a decay in the checks and balances of our Constitution that this system doesn't work. It says to federalism that there are checks and balances in the Constitution, and we must respect those checks and balances. Today, we have governors who are only hitmen for the center. How can you proceed on this particular basis? The states are impoverished. Financial federalism is at an ebb. Where have the system of checks and balances gone? It is true that the judiciary has a very important role to play as far as checks and balances are concerned. But Madan knows, and we all know, that the judiciary is under pressure both internally and otherwise. Aparna Chandra, in a very detailed account, relying on a lot of data that Madan has provided, takes us through the structural problems that the judiciary has. But I ask myself a small question. Is our judiciary being saffronized? Shekhar Yadav, Gauri in Madras. We don't know enough about the workings of the collegium to know the extent of saffronization of the judiciary. And we should know. This is an exercise that has to be taken. But you take away checks and balances, and then an elected dictatorship will prevail. And this is the failure that we have to address. I will come to know in a few moments as to what this is. Our Constitution is very, very elaborate. I reduce it to 5 fundamental texts. There are the democratic, texts of the Constitution, which cover Parliament, elections, the Election Commission, all this. Then there are what I call the justice texts. We think that the justice texts are only a concern of the judiciary. They encompass a huge area: human rights, secularism, and all the values that underlie the Constitution. The justice texts are not just a concern of the judiciary. They are a concern of Parliament, they are a concern of the executive, they are a concern of the civil servant. The justice texts will be redeemed by the judiciary, but they have to be understood as part of constitutionalism itself. My third area of what I call texts are the federal texts. The federal texts are important to take into account the great diversity of India. And they are connected, Balveer, not just to the tiny topic before us, but to secularism and our values across the board. Then come, to my mind, the civil service texts. They are important because the civil service has been given a very important role in our Constitution. Today, they are unable to lead. And finally come what I call the military texts of the Constitution. The military texts are part hidden, part in statutes. But 10 states have an important bearing on the military texts. Where do we get accountability from the military texts? I remember Justice Venkatachalaya once called a meeting. He called General Chaudhary and all the generals that were responsible for the military texts. We met in Vigyan Bhavan, and the question was, how can we get more accountability from the military texts of the Constitution? There is parts of India that are governed by these military texts, and if we don't get accountability, then something in our system fails. Now put all these texts together and ask yourself the question, are these texts, as we know them, subject to and undermined by India's present dictatorship, which is fueled in a very big way by fundamental nationalism? And it is important for us as constitutionalists and for the people to recognize this undercurrent of these texts and to bring back checks and balances. I have one other important point to make before I go a little further. You know, Mr. Vohra has taken us through past, present, and a bit of future. It was not like this before. Nehru is much reviled, but you know, once he gave a speech on the 7th Fleet outside Parliament. The question was, did he violate parliamentary privilege? Nehru immediately apologized and said, I will subject myself to the processes of Parliament. Never happened. He was called for contempt in 1958 before the Madras High Court. He instructed his people, go and fight the case. This is the checks and balances of the Constitution and our constitutional understanding of it. When we get to the question of federalism, which is a main topic here, what are we to do with governors today? As I said, they are the hitmen of the center. Can Delhi's governance function without any control on its services? Can they control under the tutelage of the Lieutenant Governor? Can Madras continue with the governor taking one side, or can West Bengal do it, or can our governor of Kerala, as he then was, refuse to sign bills? I asked Mr. Vohra and others, is there not a better way of appointing governors? Should we get away from this patronage system to something more meaningful, something more exact? Because the governors have dissolved the federal system. Go a little step further. Article 356, President's rule, imposed more than 100 times. Does it not interfere with democracy? You disrupt the democratic system and take it over completely. Now, if the center can function without president's rule, so can the states. And we should, because Article 355 to protect the union is enough, we should consider an abolition of Article 356 completely. It is an offense against democracy. It is an offense against federalism. Now, I'm not saying that there weren't good governors in the past. I remember interviewing for my book on President's Rule, Dhavan. I asked him, why did you not agree to postpone the election for 19 days? He looked at me and he said, I think I made a mistake. Now, good governors can make mistakes, but bad governors are bad governors, and we need to examine every aspect of their rule. Today, democracy in Delhi lies shattered because of the lieutenant governor. It can't proceed. You take away civil services from him, from the government. Supreme Court says you must restore civil services. 2 paragraphs in Justice Chandrachud's judgments, para 96 and 104, are used by Amit Shah on the floor of the House to say that you can use Parliament to change the law on civil services. Before Chief Justice Chandrachud, the matter lay fallow for 11 months. It has still not been decided. Now, my late father was the governor of West Bengal. I believe he made one mistake. When Jyoti Babu came to him and said, I'm a minority government, you in Rajya Bhavan don't decide. My father said, we are under emergency rule. Jyoti Babu said, you still don't decide. And we have to get into this question of minority governments. I remember I was a student, I wrote to my father, he may well have been wrong. You know, this idea that governors have adopted, that you must have confidence motions, is an absurdity. It means there can never be a minority government in any of the states. The correct approach is that you should have a debate and a no confidence motion on the floor of the House. Confidence motions destroy minority governmentship. But come back to federalism. Our states cannot be reduced to penury. When the 15th Finance Commission came, it altered the very scope of our understanding on financial federalism. GST has had a big impact, and one of the judgments of the Supreme Court by Chief Justice Chandrachud, my friend Mahesh is working on GST, emphasizes the fact is that the GST Council is not binding in all regards. What Mahesh is working on is something the Supreme Court talked about, a dispute resolution council within the apparatus of GST. It has still not happened. We can't have a federalism, a financial federalism, based on a begging bowl. Now, what happens politically? If you want resources from the central government, you join the NDA. Otherwise, what we have is a vindictive federalist, financial federalism, which will put our democracy in difficulty. There is one important point, and that's my third point, and finally I'll make one more. In a recent lecture, Balveer Arora made a very important point about the distinction between government and the state, government and the Constitution. If government overwhelms the Constitution and the state, a great deal is lost. We can't have Indira is India, India is Indira. We can't have Modi is India, India is Modi. The government has to be separate from our understanding of the state which is embedded in our constitutional system. And I look at it very differently. I don't know, Madan, where you stand on constitutional morality. I'm dead against it. Constitutional morality can be picked up by anybody. Modi says he advances constitutional morality. Supreme Court, some judges say they advance constitutional morality. It is an exercise in relativism that doesn't take us anywhere. And an interesting illustration of this is the Sabarimala case. In Sabarimala, Justice Chandrachud said, my constitutional morality is part 3 of the Constitution, egalitarianism, liberty. To which Indu Malhotra gave the reply, my understanding of constitutional morality is plural secularism. So how do we bring in what I will place before you as an exercise in institutional morality? This is what I say at the end of my examination of President's Rule. Institutional morality means every process, every institution within our Constitution has an inner morality. That is the best practice. It is that institutional, which Mr. Vohra pointed out, it is that institutional morality that has failed us over the ages. And we have to build up and understand our Constitution in terms of the institutional morality of the civil service, of federalism, of the parliamentary system. There is no point saying there is such a furor in Parliament. You don't let Parliament debate, there will be a furor. What do you expect? Now, yesterday, there was some confusion over the Waqf bill. There was an agenda. You don't follow the agenda. You break the agenda and then blame people and suspend 12 MPs for breaking it. Either we understand the framework of institutional morality and the working of Parliament and including the judiciary, or we don't. I finally come to my last point, my fourth point. What are we to do about it? Things will improve, morality. I believe that people's activism within the framework of the Constitution, within the framework of our understanding of media, within the framework of our elections, within the framework of our federalism, is the only answer. It is people's activism that helped Nehru and discussions to keep the Constitution in place. It is people's activism that humbled Mrs. Gandhi and led to Madan, the post-emergency Supreme Court. It is people's activism at all levels that have engaged. We will get Bhima Koregans. That is part of the depressing part of our elected dictatorship, which will use the Enforcement Directorate, PMLA, Unlawful Activities Act. And this can only be addressed if the people use the processes of the Constitution. I will end up with one little reverie. When I was arguing Babri, one of my purposes was to bring the Places of Worship Act in place. Now, that had no place in a suit which was concerned only with titles. So I said, we must look at it constitutionally. So Justice Chandrachud asked me, what do you understand by the Constitution? I said, passion. Passion. And I abbreviated a share in Urdu to say, दो तरह का दिल संविधान को चाहिए, राहत में एक मुसीबत में चाहिए. Friends, this is the time of musibat. This is when we have to resurrect the Constitution. I thank you.
I now call upon Justice Lokur to please address us.
Yeah, thank you, Mr. Vohra, and good evening, everybody. You know, some of the questions which Professor Balveer Arora raised are, in a sense, out of course as far as I'm concerned. My knowledge of many of the issues that he has raised is quite shallow. But some of the other issues, you know, about federalism and integrity of institutions, yes, I would like to address some of these issues. But let me begin by discussing constitutional morality, which Dr. Rajeev Dhavan does not believe in. I am a great supporter of constitutional morality. And I'll explain to you why I believe that is important when we are discussing the integrity of institutions and when we are discussing federalism. There is a philosopher teacher in Harvard University whose lectures have been extremely popular. And one of them, you know, deals with issues that arise in day-to-day life as far as the law is concerned. And that has been converted by him into a book. And the title of the book is very important. He asks the question, Professor Michael Sandel, what is the right thing to do? I think that is a question that all of us need to ask when we are taking a decision. What is the right thing to do? Now, the Constitution of India is the largest constitution in the world. The American Constitution is perhaps the shortest constitution. England, as you know, does not even have a constitution. But the Constitution of India, in spite of its length, is not expected to be and is not intended to be some sort of a standard operating procedure. That if this thing happens, this is what you do. If that thing happens, you do something else. That's not what the Constitution of India is. It's a sort of a charter of governance where fundamental rights take importance, and of course, the various institutions of governance, such as the judiciary, the legislature, the executive. So each one of these institutions, when it comes to the crunch, has to ask itself the question, what is the right thing to do? So if you look at the executive, Mr. Vohra mentioned that at one point of time in the 1960s, Parliament was supreme in the sense that everything had to be decided by Parliament. The Prime Minister of India, Pandit Nehru, was answerable to Parliament, and from what I have read, he used to attend the sessions, almost every day. And if there was a question to be answered, well, he would do it, right? And as Dr. Dhavan has mentioned, he was prepared to face a privilege motion in Parliament against what he said. So really, at that point of time, there is no doubt about it that Parliament was supreme. everybody was answerable to Parliament, whether it was the civil service or whether it was the political executive. Everybody was answerable to Parliament. Now, how did that happen? That happened for two reasons, I believe. One of them is that the persons who were in positions of power at that point of time, Pandit Nehru and his cabinet colleagues, believed that it is Parliament that is supreme, and they let that be made known to everybody. That is one thing. The second, which I believe, is that the people elected Parliament. So if the people are supreme, if the people are sovereign, their representatives represent the people, and therefore they are answerable to the people, and therefore everybody would be answerable to Parliament through the people. Now, if that is the mechanics of the Constitution, there is no doubt that Parliament was supreme during that period, and it functioned effectively. There would have been, I'm sure, some disputes and debates on issues and policy and so on, but that's part of parliamentary democracy. Where did this change come about? This change came about when, unfortunately, sometime in the late 1960s or the early 1970s, when the political executive under Mrs. Indira Gandhi felt that, well, the executive is above Parliament. Even though the Prime Minister might be answerable to Parliament, but the Prime Minister will answer questions only when it is appropriate for the Prime Minister to answer questions. That's the time when the political executive took control of Parliament, and Parliament, in a sense, became subordinate to the political executive. Was that the right thing to do? Mrs. Gandhi, of course, must have believed that it is the right thing to do. Laws were passed. Article 356 of the Constitution was used, as is well known, over 100 times. And surely during the time when Mrs. Gandhi was the Prime Minister, it was used fairly frequently. Why? Because the Prime Minister felt at that point of time that she knew what is the right thing to do. And if she knew what is the right thing to do, well, she would do what she thought was correct. Events also happened around that point of time. That is the 1971 war and the independence of Bangladesh. That gave strength to the political executive. See, I told you I'm right, and I've been able to prove it. But this went, I think, a little beyond what was expected of the Prime Minister or what was expected of the political executive. And some amendments were sought to be introduced into the Constitution, which had also been amended several times in the past. But some very important amendments were sought to be introduced in the Constitution. That's where the idea of checks and balances really came into its own. When the Supreme Court said in 1973 in the judgment of Keshwanand Bharati, which I'm sure all of us have heard of, where the Supreme Court laid down what is called the basic structure doctrine, that you have a constitution which has certain elements and you cannot tinker with them. Yes, there is a power to amend the Constitution. You can certainly amend the Constitution, and it has been amended several times, but certainly you cannot tinker with the basic structure of the Constitution. And what is the basic structure of the Constitution? India is a republic. India is a democracy. India is sovereign. And through an amendment later on, India became a secular democracy. India became a socialist democracy. So the basic structure doctrine, I think, is to my mind, it's like a watershed moment when the Supreme Court, the judiciary, one of the organs of the state, said that, all right, the legislature may be supreme. Today, the political executive may think it is supreme, but ultimately it is the Constitution of India that is supreme. That is something that was laid down by the Supreme Court when it enunciated the basic structure doctrine. That you can amend the Constitution by all means, but not its basic structure. So I would say that, maybe the first 2 decades, 1950s and 1960s, when the nation was being built, when institutions were being built, when governance was something perhaps in a sense new, when federalism was perhaps new to the governing body, to the governing polity, things went along, fairly smoothly. The executive knew its place, the legislature knew its place, the judiciary knew its place. We had issues at that point of time in the 50s and 60s. Human rights, of course, were important, but you had things like trade and commerce. What is the freedom to trade? What is the freedom of commerce? What is the freedom of speech? What is the freedom of expression? What about movement? What is the freedom of movement? All these issues which form a package deal, so to speak, of federalism, of democracy, they were debated and discussed in a calm and sober manner in the Supreme Court and, of course, in the legislature. But the problem started, in a sense, in the 1970s, late 1960s, early 1970s, when the political executive felt that it was more important for the governance of the country than Parliament. One thing led to another. Perhaps the Prime Minister felt that, well, it doesn't matter if I can use official machinery for the purposes of my election campaign. And she did. That's when the judiciary stepped in. Justice Jagmohan Lal Sinha said, sorry, you can't do it. It amounts to a corrupt practice. And the election of the Prime Minister was set aside. So the judiciary at that time was also strong. It was independent. It was strong, and it could tell the Prime Minister that, listen, sorry, there's a red line that you cannot cross. That led eventually to the emergency. Again, the assertion of power by the executive, by the political executive, which not only resulted in just about everybody from the opposition being sent into house arrest or sent into custody, but also prolonging the life of Parliament. So while the political executive knew that it had the power to do what it wanted to, it still needed the sanction and the imprimatur of Parliament. And so Parliament was extended from 5 years to 6 years or 6.5 years. So really all these three organs of the state, so to speak, the executive, the judiciary, and the legislature, till then were working in harmony. Each had their own issues about supremacy, but each realized at the end of the day that what is important and what is supreme is not our power as the judiciary or our power as the legislature or our power as the political executive. What is supreme is the Constitution. And that's when I think things began to change in the late 1970s after the emergency was over. The judiciary had a tough time during the emergency, but the judiciary as a whole did not, in the sense that the high courts still stood up to the political executive. A large number of people had been preventively detained under MISA at that point of time. But at least 10 high courts, if not 11 of them, said that you can't do it. The Constitution does not permit this. And you have to follow the Constitution, whether you like it or not. That was also the time when Mr. Devkant Barua said Indira is India and India is Indira and so on. But the judiciary, at least at the High Court level, did not buy it. The problem came in the judgment of ADM Jabalpur, when the Supreme Court said, the right to life and personal liberty is subject to the laws, not necessarily to the Constitution. Justice H.R. Khanna stood up and said, no, sorry, the Constitution still is supreme. The emergency may have been declared through the provisions of the Constitution. The Constitution permits that. But it doesn't mean that everything goes, you still have fundamental rights. That was the right thing to do, to say that yes, the Constitution continues to be supreme. And yes, there has been a debate that, all right, the Constitution permitted a declaration of emergency. And what's wrong if under the Constitution, the then Prime Minister decided to declare emergency? What's wrong with it? The Constitution permits it. Constitutional morality did not. The emergency is not to be declared, just because you want to declare emergency. Just because you want, your election to be ratified by Parliament. Just because you want to amend the Constitution and say that, well, my election cannot be challenged. You can't declare emergency for that. That's certainly not what the Constitution makers, the Constituent Assembly had intended. That's where constitutional morality comes in. Was that the right thing to do? One person thought, yes, it is the right thing to do, but the judiciary, at least one of them said, no, it's not the right thing to do.
Legal authority.
And the people said so. Soon after the emergency was over in 1977, that no, that's not the right thing to do. So really, constitutional morality, I think, is central to our understanding of the Constitution. Where does this come in when we talk about, federalism?
Is he Groot or Groot?
You have elected governments, duly elected governments through a free and fair election. And somebody in the center says that, well, you follow a path which is different from my political ideology or from my policies, governance policies, or my way of thinking. So, okay, let me see if I can, use the powers under the Constitution again, Article 356. Use the powers under the Constitution to throw you out and, in that sense, destroy the will of the people. And that is why a large number of state governments were, denuded of their power, and Article 356 was invoked. The issue of federalism came up ultimately. Of course, it was there. The Supreme Court recognized it. But in the judgment of S.R. Bommai in 1993, they said federalism is one of the basic structures, one of the basic features of our Constitution. Don't tamper with it. And in a sense, Article 356 was thrown out of the window. Since then, there may have been some instances when Article 356 has been used, but not with the kind of frequency that was being used prior to that period. Did the Supreme Court do the right thing? I would say yes, it did the right thing, because that's what the Constitution says. That's what constitutional morality says. That don't just chuck away, a lawfully elected government just because you don't agree with the views of that particular government. Today, what we are facing is a crisis of constitutional morality. There has been a reference to the role of governors. There has been a reference to the role of institutions. Are they doing the right thing? Look at governors. What does the Constitution say? The Constitution says that if the legislature passes a bill and it has to be passed as a law, the governor has to look at it and agree. Unless, of course, there are some questions that the governor may wish to ask. In that event, it can be sent back to the state legislature. But ordinarily, the governor must accept the bill as it has been passed by the state legislature. We've had instances, not one, but several of them, in several states, where a large number, and it's across the country, Punjab, Kerala, Bengal, 3 parts of the country, a different situation has arisen in Maharashtra, which is another part of the country. But anyway, the bills were not being signed or not being assented to by the governor. Why is that? The governor says, listen, the constitution does not tell me when I should give my assent. I'll give it when I feel like giving it. Is that the right thing to do? Does the constitution, it's like I said, it's not a standard operating procedure that once the bill comes to you, sign it within 15 days, sign it within 30 days. The constitution doesn't say that, and it can't, obviously, otherwise it ceases to be a constitution in that sense. But the governor has this constitutional morality to do it within a reasonable period of time. A reasonable period of time, depending upon the nature of the legislature. It could be a week, it could be a month, it could be 2 months, but certainly not 2 years. And even at the end of 2 years, the governor says, sorry, I can't do anything about it. The matter comes to the Supreme Court, and the Supreme Court realizes that what the governor is doing is not correct. But the governor, being the governor, the Supreme Court says, well, we can't tell you what to do, You have to act in accordance with the Constitution. So please have a look. And when the Supreme Court says that, what does the governor do? The governor says, well, I think it violates the provisions of the Constitution, so I refer it to the President of India. Why could that not have been done 2 years ago or 1 year ago? So here you have this, crisis of constitutional morality, where the governor believes that what he is doing is right, because not because it's the right thing to do, but because the Constitution does not place a mandate on him. So he sits on the bill for a year, 2 years, and so on. And like I said, it's not happened in one state or 2 states. It's happened in several states, and it's not happened in 1 or 2 instances of bills being passed by the legislature. It's happened in several cases. Maharashtra, I had mentioned about Maharashtra. The state government sent a list of 12 persons to be nominated to the Legislative Council. The governor didn't do anything about it. The chief minister told the governor, we've sent you a list. Please nominate these persons to the Legislative Council. The governor refused to do it. Did not say yes, did not say no, did not say, why are you recommending these people when there are others? Or there is a problem with some persons. The governor just does nothing until the governor, retires or is, sent away. The new governor comes, and among the first few things that he does is says that I'm not going to nominate these people. Rejects all the names. Did the first governor, did he do the right thing? I think we have to ask ourselves. A duly elected government says that we are nominating these people. Unless there is something wrong with the nominations, they've not been done in accordance with the procedures, or there's something wrong with the people who are being nominated, why should the governor not accept the views of the state government? Again, did he do the right thing? Constitutionally, it's not, a personal belief, but constitutionally, did he do the right thing? That's the question you have to ask. The institutions, we'll talk about those institutions in a brief moment, but you've had situations where the Speaker of the House has declined to act. The 10th schedule was brought in to check defections. It's anti-defection law, as it's commonly known. A complaint was made, a petition was made to the Speaker to disqualify some people in Manipur. A petition was made to the Speaker in Maharashtra to disqualify some MLAs on the grounds of violating the 10th schedule. And the Speaker doesn't take a decision. He says, the Constitution does not say or the rules of procedure of the House don't say that I have to take a decision within a fixed period of time. So I won't take a decision. I'll take it when I feel like taking a decision. The matter comes to the Supreme Court again in the case of the Manipur speaker. It came also in the case of the Maharashtra speaker. The Supreme Court says that, listen, the Constitution does not say it. Obviously, the Constitution cannot. But then you have to do it within a reasonable period of time. And you've not taken a decision for months together. We think that 3 months is a reasonable period of time. Can you do it in 3 months? The speaker says, all right, I will, go according to your decision that it must be done within a reasonable period of time, but I'm sorry, I can't do it in 3 months. So he tells the Supreme Court that, well, I've not been able to do it in 3 months, I need some more time. Maharashtra, same thing happened. In fact, that petition, became virtually useless because of the elections and so on. Again, sorry, Rajeev, I'm taking time over constitutional morality, but this is what is important when we are looking at 75 years of our Constitution. What is it that our Constituent Assembly members wanted? Dr. Ambedkar said on 25th November 1949, Dr. Rajendra Prasad, who was the chairman or the president of the assembly, he said on 26th November that we have given you a good constitution, but a lot depends on the people who are going to operate that constitution. If we give you a good constitution and the people want to make a joke out of it, they can. What is there to prevent them from doing it? But if we give you a constitution which is not good, but the people who are going to operate it are good, fine, you can call it a good constitution even though it's not good. So the people who are going to, operate the constitution, I'm using the word operate, I'm not sure whether that's the correct word, but the people who are going to govern, in accordance with the constitution, if they do a good job, that's all that is required. And again, for the governor to act, well, what is it that, prevents him from acting? What is it that prevented the Supreme Court during the emergency to give the judgment in ADM Jabalpur? What is it that prevents governors from doing their duty in accordance with the Constitution? A document which is supreme and which Mr. Vohra said everybody swears by it. You have to take the oath under the Constitution, whether you're an MLA, whether you're an MP, whether you're a governor, whether you're a judge. You have to take an oath under the Constitution. So what is it that prevents this from happening? The last section that I would just like to address on is the issue of institutions which Professor Arora had mentioned. Now, there has been a lot of debate about the Election Commission. Should it be under the control of the executive? Dr. Ambedkar was pretty clear about it. The answer is no. It should not be under the control of the executive. But what is it that happened, until Mr. Session came, for example? It was the executive, the political executive, that was appointing the Chief Election Commissioner. At that time there was only one. Later on it became 3. It was the political executive that was appointing the Chief Election Commissioner. But a good person who knew that there is a constitutional obligation on him to have free and fair elections. I don't care who the government is. My job is to hold free and fair elections. And he did that. So even though the appointment was through the executive, elections were held peacefully. There were, of course, instances of booth capturing and so on. But yeah, by and large, okay. What about appointment of judges? Until the collegium system came, entirely in the hands of the executive. The executive was the one who would decide, discuss with the Chief Justice of India, and make the appointments. Outstanding judges we had. So even though the executive, was powerful, it had control over the judiciary, over the judicial appointments, it had control over the election commission, you had good people who knew that the constitution is supreme, not the political executive, not the government, not the prime minister, but the constitution. And they did their job as they were required to do under the constitution. When you had interference in the election commission, somebody like T.N. Sessions stood up and said, sorry, mind your business. Somebody like H.R. Khanna during the emergency, Justice H.R. Khanna stood up and said, you mind your own business. I am governed by the Constitution of India. So today you have, even in the civil service, why is it called the steel frame? We've had outstanding civil servants. One of them is here with us today. We've had outstanding civil servants. They've been appointed, or under the control, so to speak, of the executive. But if the political executive was wrong, they said, yeah, you're wrong. But today, what is this churn that is happening, over the last so many years? What is it that has led to the degradation, so to speak, of the quality of our civil servants, who, in some instances have become yes men? What is it that has happened that has prevented the Supreme Court from delivering judgments under the Constitution without fear or favor, without affection or ill will? What is it that has happened? We are now seeing a resurgence, so to speak, of the political executive gaining supremacy. Parliament, I'm sorry, but with all due respect, has sort of become subordinate to the political executive. It is not frequent for those who are in the cabinet to attend parliamentary sessions on a day-to-day basis like it was in the 50s and 60s. Why? Because the political executive is supreme and it will attend parliament when I need to. I will answer questions when I need to. I will talk about Manipur when I need to. I don't need to talk about Manipur. Why should I talk about Manipur? Why should I talk about human rights? It's not necessary. So when we, look at some of these institutions, Election Commission is one of them, the judiciary as a sense, in one sense, an institution. You have other institutions. You have, the Enforcement Directorate so much in the news. You have the CBI so much in the news. The Income Tax Department has started acting up, right? But you still have some other commissions. The Finance Commission, for example. You have the CAG, right? To a very large extent, the UPSC. They've been able to manage their affairs without political interference. What happens if the political executive decides to interfere? I don't know. Again, it depends upon the people who are in position at that point of time. If they're able to stand up and say, listen, the Constitution gives a certain obligation on us, it casts an obligation on us, we are going to go by the Constitution, not by what you say. Because the right thing to do is to go by the Constitution. That, I think, is really the crux of the problems that we are facing today. We need men who can, and women of course, who can operate the Constitution in accordance with the wishes and the discussions and the debates that were held in the Constitution, in the Constituent Assembly 75 years ago. We have to realize that we have given the Constitution to ourselves. And if we don't operate a document that we have given to ourselves, what are we going to operate? Are we going to expect somebody else to operate the Constitution for us? A document that we have given? I don't think so. It's not like a will, where the person dies and somebody else, operates the will. It's not like that. So really, when we look back on 75 years of our constitution, I think we have to look at some of the things that have happened. New thoughts, new ideas have been coming up. Accountability, right to information, social justice, these are things that are talked about. Are we going to foster them, or are we going to say that, well, enough is enough? I mean, we don't need accountability. Why should somebody ask us questions? I'm doing the right thing. I'm doing my job. Nobody should ask me questions. So I think we need to, to introspect, to think about where the Constitution has gone. There have been ups and downs in the 1970s, but the Constitution has bounced back because of the institutions, because of the systems of governance that we have. Today, are those systems of governance strong enough to continue to protect the Constitution, or does it lie in the hands of the people? Thank you very much.
I now call upon Professor Chandok.
Madan. Very good speech. Excellent.
After those two very learned presentations, the question that comes to our mind is a rather pensive one. Constitutions and democracies are companions. They are companion concepts. You cannot have a democracy without constitutions, which regulates and institutionalizes its values. But constitutions can include more than they include. And I just want to make a point about constitutional morality, which Rajeev touched on and which Justice Madan also spoke about. We are very familiar, every law student is familiar with Ambedkar's invocation of constitutional morality, originally put forth by Grote. Now, Grote was a Victorian gentleman. He was not a professional historian, but he was a banker, very well-to-do banker. He wrote 6 volumes on the Athenian democracy, which was the mother of all democracies. Demos is a Greek word, so let us not pride ourselves that we invented democracy. In the 1960s, E.H. Carr gave a series of lectures which later became a book called What is History? And he said Grote wrote 6 volumes on Athenian democracy. Not in one of them he mentioned slavery. He said Grote was not writing about Athens, ancient Athens. He was writing about his contemporary Victorian temperament, which was prudence and thrift and propriety. So constitutions can hide much more. They can be exclusionary to an alarming degree. And we see this happening in days of legal or autocracy, where governments are becoming authoritarian within the ambit of the law. No longer do we have military coups. I mean, those days where Costa Gavras used to cover military coups in his Z or his missing, leaving hundreds and thousands of people dead with 5-star generals, masterminding the coups have gone. It's too much of a cost that they have to pay. It's too obvious. Today they function within the law, and yet they are authoritarian. And we can name country after country. Right-wing authoritarians were present at Trump's inaugural in full force to show the shift from center of left politics to right-wing politics, which disdains constitutions, which disdains any curbs or checks and balances on power. Right-wing populists are not interested in upholding constitutions. They are interested in appealing directly to the people and attacking institutions and constitutions on the ground that they are elitist. They embody elitism and they perform all the rituals, but they don't heed the constitution. This is certainly not happening in India. I want to make 3 points which I think we are running out of time, so which sharp points and after 2 legal minds, you have a political theorist presenting her point of view. Yet constitutions are important, and I'll just talk about, there was this OTT series called Dhavan, directed by Reena Kagti and Zoya Akhtar. In this, Sonakshi Sinha, who's a police officer, who's from a so-called lower caste, is denied entry into a Thakur's mansion on the ground that she belongs to the lower caste. Towards the end of the movie, she tells him, I can enter, my constitution permits me to do so. So I suppose the utmost we can expect from the constitution is that it will protect the marginalized. Whether it has happened is anybody's guess. So what is the constitution about and why should we value it, despite all its shortcomings? And despite several Chief Justices who have betrayed our confidence in the ability of the Supreme Court to be the upholder of the Constitution. I'm not going to mention that in detail. We all know who they are. First of all, the Constitution is not only a legal document, though it has become the provenance of lawyers, and this is happening the world over. It is courts, not parliament, which are the site of politics' contestation. Our Constitution comes to us from the national movement, from a mass struggle. 1895 was the first time in the public sphere a Bill of Rights was introduced. Nobody knew who had written it. Annie Besant thought Tilak had written it. But it embodied the liberalism of the 19th century, civil liberties, right to express yourself, right not to be arrested, right to have property, and the right to vote. It did not mention self-determination. That was not the political discourse of that time. In 1924-43, men of eminence got together and prepared a Commonwealth of India bill, which was again, made the Bill of Rights the center of their document and sent it to the Labour government in England. The government piloted this bill through the first reading, but then the government Labour Party lost its majority and the bill lapsed. 1928 is the Motilal Nehru Constitution draft, which actually is remarkable. Granville Austin says it serves as the foundation of the present Constitution. It incorporated minority rights, and therefore we see our Constitution was a product of compromises. When Lord Birkenhead, the Secretary of State for India, challenged Motilal Nehru, show me, this is the aftermath of the unrest over Simon Commission. He said, show me your people can write a constitution which brings Hindus and Muslims together. So the Congress convened an all-party conference, and Motilal, they went to the Muslim League. The Muslim League said, put in separate electorates. The Congress was against it. So what they did was the first time in history they introduced minority rights. It was not a new concept. The League of Nations had introduced it, but introduced it in India. They didn't mention secularism, but they introduced minority rights, which later became Article 29 and 30 of the Constitution. The second productive aspect of the constitutional draft, Motilal Nehru constitutional draft, was the integration of various political, civil, social, and economic rights into one document. The Constituent Assembly split them into two and made social and economic rights part of the directive principles. And thirdly, the Motilal Nehru draft constitution provided for universal adult franchise. Now, this is a time when what was known then as Ceylon had also prepared a constitution. They didn't give the vote to women under 30. Why 30? I'm not able to understand. But women below 30 could not exercise their franchise. It was this time they institutionalized the notion of universal adult franchise. The second important aspect, historical aspect of our constitution was that it was written by Indians. That was a demand of the Indian National Congress since the 20s. Mahatma Gandhi wrote on it, Nehru wrote on it, and the British cabinet kept refusing it, we will give you one. And every other colony in the British regime or under French colonialism got constitutions written, written for them by the imperial power, including Sri Lanka. But Indians kept insisting, 1946, when the cabinet mission plan happened, they said, yes, set up a constituency. For the first time, they said, set up an advisory committee on fundamental and minority rights. But the Indian National Congress and the history of constitutionalism is indistinguishable from the mainstream national movement, that is the Congress. And an advisory committee was formed. You know what happened. In the Constituent Assembly, there was consensus on many things, but they didn't mention secularism. Gandhi had said after the Karachi riots in 31 that when they met and the Karachi resolution on fundamental rights was drafted, Gandhi had said very specifically, the state should be neutral between religions. This did not happen. But I'll come to that a moment later. In 1947, the partition happened, a partition which had been the culmination of years of communal strife. People were divided, livelihoods were destroyed, lives were destroyed, mass rapes happened. The poet Agyay sat on the platform of Punjab railway stations from August to October 1947 and scripted man's inhumanity to man. The phrase is that of A.E. Housman. And he said, Mere desh ko mirgi ka daura pad gaya. This is an epileptic fit. It could not be happening. It happened. The Constituent Assembly met in December 46. It was witness to the carnage during the partition. And still we got a democratic constitution. We have to applaud this. But more importantly, in a country where religion had been politicized and people thought of themselves primarily as Hindu and Muslim, how do you create a political community? How do you create a political democratic community? There was a third way. And this way was pointed out by M.S. Satyu much later in his Garam Hawa, his famous Garam Hawa, where at the last scene, Balraj Sahni very reluctantly locks his Haveli in Agra and prepares to go. He doesn't want to go to Pakistan because it is fundamentalist and Islamic, and he doesn't want to stay in India because he's subjected to such humiliation. He gets onto the Tonga, and the Tonga wala looks at him and says, Musalman ho? He says, yeah. He says, for you, double the price, double the rates. In the mean, very despondent Balraj Sahni, he sits in the Tonga, and then he sees a procession of people carrying red flag with a hammer and the sickle. He stops the Tonga wala, he gets off from the Tonga, straightens his hat and joins the procession. There is a third way. There is a third way between Hindu communalism and Muslim communalism. The first producer, sorry, I'm a movie buff, so I can't help recounting these stories. The first producer who talked about Hindu communalism was B.R. Chopra, who himself was the victim of partition. And he was directed by his brother Yash Chopra, Dharamputra. In that, Shashi Kapoor is a Hindu Mahasabha guy. And then he comes to know he's actually a Muslim. And there's a Qawwali, you know, Sahir Yudhanvi, the great Sahir Yudhanvi. I wish somebody would give him a Bharat Ratna. He says, ये मंदिर है वो मस्जिद है मकसद तो उसी की बात से है तुम राम कहो हम रहीम कहें मतलब तो उसी की ज़ात से है. And then when the famous Ishq Qawwali in Barsat Ki Raat Sahir lies, हिंदू ना मुसलमान है इश्क खुद ही धर्म है और खुद ही आप ही ईमान है इश्क. You look at the Urdu writers of the Progressive Writers Association, which was assembled in 1936, what they did was to create a political community. Now, a political community is independent of the procedural rights of institutionalism. It is a community where people can debate and dialogue and talk to each other about what is and what should be. It's the Greek model of deliberation. This political community promised a third way out of Hindu and Muslim communalism, and is this in our preamble. And the one emotion that tied members of a political community that very recently had seen their families being butchered during the partition was fraternity. I'd rather call it solidarity because fraternity is a gender-specific word. And solidarity was a provenance of the critical theory school in the 1930s. It has not been used after the critical theory school kind of disappeared with the Holocaust in the 40s. Fraternity gives you a new set of values to relate to each other, and believe me, a political community cannot rest on the dry bones of the law. It's very dry. Law is very dry. It cannot rest on constitutional provision. It has to rest on what Adam Smith called, in his theory of moral sentiments, called sympathy. And we have sympathy because we have imagination. We create a political community which unfortunately has been destroyed in the last 10 years and the politics of fear and the politics of suspicion and the politics of hate and the politics of being wary of the other have once again overtaken us by relentlessly making us remember the partition. We were not even born then, my generation, though I am the first generation of independent India. But this is what has happened to the political community, and I think this is a shame because what the legal autocrat wants is a split in the civil society, is a split in political society. Because the more people are split, the less he will have to convince them that his ideology is the best. He's a Superman, non-biological. I mean, Trump said, God has sent me to save America. What world are these people living in? You're representatives of the ordinary human being living in your country. In a way, this political community has been sundered apart, and I would suggest if we want to restore the sanctity of our constitution, we have to rebuild the political community. We have to establish strains of solidarity between people in political communities, solidarity that can erupt every time a Dalit is insulted, every time a woman is raped, every time a Muslim is insulted. Because believe me, the politics of recognition tells you that when you humiliate a person, it leaves scars. It leaves scars the way rape leaves scars. It leaves scars the way bodily assault leaves scars. Be careful of how you treat other people. Treat them as other human beings. Talk to them, have conversations, have dialogue. Because through conversation, you recognize the other as somebody who's worth talking to. We don't talk to people whom we think are not worth talking to. Through conversation, you actualize the humanity of the other individual you're speaking, irrespective of their religious affiliation or their caste affiliation. We need to rebuild a political community, associational life, which has been destroyed in the recent past. Thirdly, secularism. Very clearly, there are demands for removing secularism. I once wrote a piece in the Wire thing, will you please stop hounding us? I wish that lawyer who keeps taking cases to the Supreme Court saying remove secularism would have something else to do. Usko koi kaam nahi hai? He just keeps saying, remove secularism. Please, spare us here. Stop hounding us. We have lived together. We will continue to live together as fellow citizens, members of the political community, bound by common allegiance to the Constitution. We not only owe obligations to the state, and I'm distinguished from government, we owe obligations to each other. This is what the theory of justice says. We owe obligations as fellow citizens, and for that you have to create a political community. Otherwise, this will continue to happen. Third is secularism. The word secularism, the concept of secularism was really not elaborated at the Constituent Assembly, though Nehru kept tugging at whatever hair he had and saying, you guys don't know what secularism is. It arose in three contexts, which had nothing to do with how the state treats religion. So we left the task of defining secularism to the Supreme Court. Sorry, because Justice Madan has been a member of a Supreme Court which ruled that you cannot deny that India is religious. Well, if India is religious, learn to treat all religions equally. You see how the concept of secularism, which comes as distinct from secularization, where religion becomes privatized, secularism means that you will not discriminate against any community on the basis of their religion. And everybody goes to the Bommai case. It took me years to read the various judgments on the Bommai case, and they all said, it stems from the Hindu principle of Sarv Dharam Sambhav. And Bhikkhu Parekh has made a very interesting observation. He says, why are you deriving secularism from a Hindu principle? Muslims and Christians do not believe there are various paths to the truth. They only believe in the one path. And Buddhists and Jains don't even have a God. Why are you doing this? Why are you Hinduizing secularism? I wish to ask the honorable judges of the Supreme Court, not you, Justice Madan, because you were not a party to it. But the Bommai case has completely ruined our understanding of secularism. And as a last point, may I say, perhaps it's time to secularize secularism by relating it to Article 14, that is the article of equality, on equality, and its weaker form, non-discrimination. And it's time the political community gets up and says, will you please stop this? When Manipur was happening, I remember Nelson Mandela, when he came out of out of prison after 27 years, the first thing he went to do was, stop it, put all your guns in the sea. Is there anybody with a moral standing today who would get up and say, stop it, no more violence? We have to get together, we have to take a stand and say, Article 14 and Article 21 of the Constitution are our Bible. They are our Talmud, they are our Gita. Abide by them. And if a government does not abide with them, off with their heads, as Alice in Wonderland, the Queen said in Alice in Wonderland. That's all I have to say, that all suggestions to improve the Constitution are not going to succeed, because today you have a situation where the Constitution is being used as a fig leaf for authoritarianism. And that authoritarianism, unfortunately, and maybe one last point, this authoritarianism across the world has been met by what is called leaderless revolts. What happened in Bangladesh and what happened in Sri Lanka. But you see what is the state of Bangladesh today? Remove secularism and socialism from the Constitution. It seems to me that lawyers should be given briefs, otherwise they'll end up doing stupid things like do this to the Constitution and do that to the Constitution. I'll end here. Thank you.
Thank you, Professor Chandok. Ladies and gentlemen, we have come to the end of our discussions. I'm extremely grateful to each of the distinguished panelists for having spoken to us at considerable length and commented on and clarified many issues. Now, Professor Arora tells me that originally we were to close this session at 6:40 and had some time for questions. But we will, if you all agree, spend the next 10-15 minutes in requesting the panelists to respond to questions. And I would particularly request that questions may be questions, sharp, brief questions, not commentaries on any particular matter. And I request Professor Arora, who is going to moderate this session. Professor Arora, please.
So the rules of the game have been spelt out. When you ask your question, please mention your name and please be brief. Mr. Pandey.
Amitabh Pandey. 3 observations, questions. One is that somewhere in the federalism discourse seems to have got mired into a legalistic, juridical vocabulary and forgotten the political and ideological edge which federalism has. And federalism is a means of protecting against the tyranny of the big state. That's what its philosophical origins are. And can we do something to revive this political edge which federalism has, because our political opposition doesn't ever refer to federalism as one of its, as a part of its agenda. Except in Karnataka, we've never seen federalism feature as a part of the political opposition. So is there something that can be done to reviving that part of the thing? The second is the bogey of national security has been one of the principal means of diminishing federalism. Because on grounds of national security, you take all kinds of unilateral decisions which are completely against the spirit of federalism. The third is a specific comment, and I'd like Mr. Vohra and Justice Lokur to answer, that the misuse of Article 356 in the case of J&K for the revocation of Article 370, because J&K was already under governor's rule and there was no failure of constitutional machinery when Article 356 was imposed and J&K brought under the control of the parliament, and that was the stratagem used for revoking Article 370, and that has surprisingly gone completely ignored, not only by the Supreme Court, but by the entire the discourse on Article 370.
I think you could have 2, 3 and then combine 3. So I have 2 hands there. So I think it will facilitate the mic. It will just have to go from one to the other.
I'm Niranjan Sahu. Very, very insightful articulations. I have just one question, I think addressed to Justice Lokur and Dr. Dhavan, about constitutional silences, which actually, you mentioned about constitutional morality, but the problem about, many of the articles, while we had the longest constitutions, but on many key provisions, the constitution makers kept it silent. Like, Article 324, you look at Election Commission, it was created, but there was nothing about the appointment process, which ultimately has led to a very convoluted process now. And then issues about governors, like you yourself mentioned, governors were given a kind of position, and many articles were there, but the power, even keeping the bills and all that, you should have a clear, actually kind of, sort of deadline or something, some kind of articulation there. So that those clarity has also brought a lot of actually problem that we face today.
You made your point.
Yeah, okay. Yeah.
My name is Dr. Sarjeet Dudeja. Under Constitution, we have been protected as equality. But if we go by economic equality, when we say GDP is the 5th economy in India, and at the same time we say per capita is a very 150th. So when we have equal opportunity for economic, so that there is no such a big gap between have and have-nots.
The inequality. Okay, thank you. And one last question here, and
Yes.
then we'll...
Yes, one question.
Huh.
Jacob John, my name is. The definition of institution was repeated several times, but we just get ambiguity as a definition back to say that's what's to be understood more than the institution that's to be, in place. It's never back in place. It's not put back in place.
Okay.
So it's like GST has been charged over the MRP for more than 5-10 years now, than just 1 year when they realize it is being played over the existing taxation. So you get to pay twice as much taxation already.
Okay, thank
That's
you.
the consideration
I think
now.
we'll have, if I can ask the lady there to, there. Please.
My name is Rani Shankardas. I'm actually pointing this question both at Rajeev, Dhavan and Neera. Neera rightly said, look where the word democracy comes from. I think if we concentrate on its Hindi equivalent, Prajatantra, which brings Praja into the picture, and hence parliamentary sovereignty, which was mentioned, that parliament is supreme, and also tied with Rajeev Dhawan's point about electoral dictatorship, emphasis being on the word electoral. So if there are 4 or 5 subtexts in the Constitution, and one of them is the electoral text, if you talk about the present electoral dictatorship or any other, what is normally, I mean, I talk as a layperson from the public, not in any professional capacity. When the question is put that any government acting on behalf of the state is a dictatorship, it is always said by most people, but it is elected. It has come through, as Madan Lokur said, through duly elected, fair and free elections. Now, is a democracy then equivalent or simultaneous with the electoral process? Or is there something else in democracy which either Neera or Dr. Dhavan can elaborate?
There's more to democracy than electoral democracy.
That's what I'd like to have explained.
And I think with the last one there, then we'll come back. Meenakshi Gopinath.
I have a question, but since you're giving me the opportunity, I just wanted to thank this distinguished panel. It's been absolutely outstanding. I did have 3 questions to 3 of the speakers, very briefly. Justice Lokur, I did want to understand whether this whole issue of the Supreme Court taking suo motu cognizance of offences like happened in Manipur, what happened to that tenet? The second is to Professor Dhawan.
One-word answer.
What is the state of public interest litigation in India today? Status. And third is to Dr. Chandok. I'm a great admirer of her work. When you talk about building this political community, what we are actually witnessing is the transformation of a religious community into a very potently harmful political community. So would you respond to that? Thank you very much.
Thank you, Dr. Meenakshi Gopinath. So we'll have the responses now, and then we take another round. Right. So
time over, okay. 9.
In the same order, Rajeev, would you like to come in first?
Look, I don't want to get into the wider questions of democracy or secularism. It is a big debate. Ashish is sitting here. He creates a reified version of secularism and then criticizes it. That's a huge debate. And I believe there is a central weakness in getting into that debate in this shortage of time. I am concerned only with the here now. Dr. Shankar Das's question of electoral dictatorship is an important one. A dictatorship cannot hide behind an electoral democracy. It simply cannot. There's a blitzkrieg of question, and I'll address only one. Of course, you are right about the myth of the law and legal juristics. But it is a part of our understanding of how we live, and it must increase. I will answer one other question on JK and then nothing more, because I'm concerned with the here now, the crisis we face when we go into 26th January 2025. I have not addressed any other questions. JK is a very important question because it was a collapse of every principle of federal democracy. Most important is Article 3. The weakness of our Constitution and why we are called quasi-federal is because there is no territorial integrity to any state. Article 3 was murdered in the debate and in its use. If we want, and UP is the only state that has to be disaggregated now, this disaggregation of states into territories otherwise must stop. But look at one aspect of JK that comes out of the judgment. The Sixth Amendment of the Constitution said that about 50 articles of the Constitution will not apply to JK. This was a constitutional amendment. How can you change a constitutional amendment by the processes of Article 370? A constitutional amendment can only be changed by Article 368 by the majorities of Parliament and the states. I think that we can answer all these questions. There is a time and place to answer many of them. I think the crisis that we face right now has an immediacy to it, and I was only trying to respond to the immediacy. Questions on the mythology of law, I will pick up at some other point in time. I have no disagreement with Madan on constitutional morality. We're saying the same things. In fact, every illustration that he gave was an example of the importance of institutional morality in every process or institution of the Constitution. You have raised some other questions as well of the silences of the law. I think Madan has answered many of them, and I don't need to elaborate.
Will you take up some?
Yeah, okay. Yeah. One, Meenakshi, is about PIL, right? You had asked about Manipur. I've given the answer, one word. No, nothing has happened. But PIL, I think, is extremely important, right? And Rajeev has done a lot of work on PILs. The whole idea of PIL was to give justice to people who were on the margins of society and could not, go to the constitutional courts. So right in the beginning, you had bonded labor. I mean, can you imagine bonded laborer going to the Supreme Court? It's impossible. But PIL enabled the bonded laborer to go to the Supreme Court. So I think, it started off extremely well. And like all, things that happen, there has been some mischief in the sense that all kinds of cases have been filed. Neera had mentioned about some advocate filing a case about secularism and so on and so forth. So yeah, but I think ultimately it is for the Supreme Court to say that, listen, we are going to entertain this petition or we are not going to entertain this petition. The newspapers play it up, this case was filed. What is the point of saying that this case was filed if the Supreme Court has not entertained it? So PIL, extremely good. I'm very much in favor of PIL, provided it has been described as an unruly horse, but control it. It's ideal for our system today. The other thing, Amitabh, you had mentioned about the state legislatures. The only thing that I would like to say is that, the states have a lot of power in the federal structure, but they're not aware of it. That's my view. And they don't know how to use it. I'll just give you one example to indicate that. Rajeev had mentioned about a particular judge as a part of the saffronization of the judiciary. Under the collegium system, the High Court makes a recommendation which goes through the state government and the Chief Minister to the Supreme Court, central government and Supreme Court. This person whom Rajeev was talking about, the state government did not object. And it's not, it's an opposition-ruled state. So at that point of time, the state government could have stalled it, and say, we have objections. So I think the states have not realized the power that they have. And, that's perhaps one of the reasons why, federalism is kind of not strong enough. Okay, thank you.
Can I just add, PIL is part of people's activism. It's a very important part, Madan.
Yeah. 1 minute. Neera, would you like to pick up something?
Yeah, I kind of agree with Rani about electoral dictatorship and the importance of elections, but we must not forget that elections are but one moment in a democracy. Democracy is much more than elections. It is minimally about procedures and processes and checks and balances when decisions are taken, as opposed to the arbitrary rule of authoritarian rulers, which the Democrats, early Democrats, positioned themselves against. The importance of institutions and processes, and not even going to the romantic version of democracy, which is about giving each individual agency and the freedom to realize himself or herself in circumstances of her own choice. That is not an option for us any longer. But democracy is about taking decisions through considered and reflective judgment, which is guarded by a whole process of institutional checks and balances. And that has really gone. And that only happens when you have a populist leader appealing above the head of institutions to the people. And in the process, downgrading the institutions themselves, though he doesn't dispense with them. I mean, that is a very unique form of legal authoritarianism. As for Meenakshi and her thing about political, may I remind you the first thing we were taught in political science, that the state of politics depends upon the politics of the state. Whichever party is in power, their ideological outpourings or their ideology shapes public opinion. That is the incontrovertible evidence. There are a group who disagree. I'm not saying, and they keep wondering, Stephen Greenbolt, who wrote on Shakespeare's Tyrant, said, what is it that gives mediocre people this charisma? And he was writing of his times, particularly about Elizabeth I, gives them the right to subject people to the kind of indignities they are subjected to. And his whole book is about Shakespeare's plays which dealt with this issue of tyranny. But the point is that, final point, our Constituent Assembly was animated by the two principles that have animated every liberal. Majoritarianism is a threat to democracy, and demagogues are a threat to democracy. Yeah. Majoritarianism rides roughshod over checks and balances, and demagogues ride roughshod over everything. And Ambedkar had warned us, be careful, do not leave your liberties at the feet of great men. He was quoting John Stuart Mill. I think what he said exactly, I'm just synopsizing it. He said, they may be great men, but do not leave. And he quoted the Irish patriot Donnell by saying that, you should not give up your civil liberties. And then he added something which is very sexist, which I'm not going to repeat. And Ambedkar said, in our country it's difficult because we have the Bhakti tradition. And in the Bhakti tradition, the individual is seen as the embodiment of wisdom. And the link between the divine and the human kind of fizzles out. And therefore, this human, in this Bhakti, it is difficult, but be careful, do not leave. I think he said, do not leave your civil liberties at the feet of men, howsoever great they may be. And it's time we start taking Ambedkar very seriously, because he brought this terrific perspective on the fear that all liberals have of demagogues. Whether we can prevent them in the present scenario is debatable.
Right. Thank you. So we have time for just two questions, one yours and one behind there.
Thank you very much, Mr. Arora, Dr. Arora. It's been, of course, a wonderful and so enlightening to listen to all the distinguished speakers. My question is, our Constitution has gone through nearly 120 amendments, and given the 140 crore population, 75 years, can't we keep the basic structure and then get the new Constitution rewritten by artificial intelligence?
Okay.
Because the technology today dictates. And for all the younger generation, it is technology and social media. And hardly any percentage of our population would even have seen the picture of the Constitution except for the cover.
This one took 2 years, that will take a few seconds.
So, and in the light of the G20 definition about one planet, one family and one future, our Constitution does need a rewriting.
Okay.
Thank you.
Next question, and this will be the...
So this is to Sir Vohra. that how far have the civil servants, the police, have contributed to the elected autocracy in the country? Autocracy. How far have the civil servants, the police, the non-elected bodies, aren't they primarily responsible more than the politicians?
Okay,
Thank
okay. Sharp and crisp, yes.
My name is Praveen Dhawan. I run a paper called The Secular Savior. Now, one of the definitions of secularism is that the state has no religion. If that be so, how this government is getting away with spending crores and crores of money on advertising for the Mahakumbh and earlier for the Ram Mandir? Why the Supreme Court cannot take a suo motu action? Thank you.
Okay. Where? There?
Gender equality. I thought you want to ask.
Okay, my name is Kamal Malhotra. My question is to Justice Lokur and to Dr. Dhavan particularly. Given that there's a crisis of both constitutional morality and institutional morality, and we have a dysfunctional parliament which is supposed to represent and be above everything else, doesn't it require an Herculean effort from the judiciary in particular now? We have to rely on the judiciary more than ever before. And what more can be done by the judiciary in this particular crisis that the country faces?
Right. I think we are running out of time. The young man there is the last questioner, please.
Hi, audible. Good evening, panelists. Dr. Dhawan and Dr. Chandeep talked about people's resistance and political communities. My understanding of the present situation is that the ruling government has rightly tapped into something which was already there, and that by that I mean hatred or exclusionary sentiment of the people. So my question to you is that when talking about the people's resistance and political communities, how do you see that happening? Is that something that would suffice when seen in context to people's resistance, and will a political community be able to take form when seen in the present situation? That's it. Thank you.
Okay, thank you. Thank you for your questions. It's been very rich. Neera, that was a direct question, and Madan, would you like to take up?
Go ahead. After that.
Yeah.
Well, I think Vohra's up first.
Yeah.
There's a question directly to him by Mr. Mahesh.
Well, Mahesh, I thought you are still in service and you would know better what the answer to the question you asked me. I shed my uniform 40 years ago. But anyway, the point that you made is far more serious than you have tried to frame it, the way you framed it. The civil services, the bureaucracy, at least the superior civil services, have a very close and accountable relationship with the political executive, the minister and the secretary to the department, secretary to the ministry. Now, from as early as the 1950s, there have been cases, instances of pliant elements being found to carry out unlawful orders or unconstitutional behests. That was not too often, but it happened even in the 50s. I am talking of Punjab in the times of Mr. Cairo. He was a great nation builder. He was a person who built Punjab, but he also destroyed the fabric of good governance. Likewise, as in any period of our evolution, our growth and development, you would find in any cadre, police, IAS, foreign service perhaps, not because foreign service deals more with affairs outside the country and you can't easily find fault with them because you know very little of what they do. But in other services, cadres are large and It's not be very difficult to find pliant persons to do what is required to be done by a political executive at any given point of our evolution. So that is the brief answer, that you have your own colleagues who will step forward and say, sir, I'll do it. Who's this Mahesh character? Throw him out.
Madan.
Yeah. Okay, Kamal, your question was about the exercise of power by the Supreme Court in certain situations, and also I think somebody had asked about suo motu exercise of power. You know, there's just that much I think the Supreme Court can do. And the reason for that is, said several years ago, 250 years ago, by Alexander Hamilton, when he was writing the Federalist Papers. And he said that the judiciary is the weakest branch of government. Why? Because it does not have any control over the purse strings, and it does not have the sword to implement its orders. So really, that's why people say that even though the Supreme Court is the guardian of the Constitution, it only interprets the Constitution and laws, of course. But the enforcement is the problem. That is done by the executive. So even if, and there's so many cases where the Supreme Court has passed orders not being implemented. A lot has been talked about police reforms, Prakash Singh's judgment. Not implemented. 2006, we're almost 20 years down the line. Supreme Court can't go and say that, listen, you better implement it or else, That's the problem. So, at best, the Supreme Court can say, well, this is what the Constitution says, this is what the law is, this is what should be done, but ultimately it is somebody else who has to implement it. That's the only answer that I can give.
I will answer 3 questions that have been raised. The first is this ridiculous question of artificial intelligence for construing a constitution. I go by what Fali Nariman once told me about our Constituent Assembly process. With all the compromises that have been mentioned on the panel, it is a miracle that we have a constitution. This miracle cannot be replicated by artificial intelligence. What happened to the Pakistan Constitution, which came in 56? It disappeared in 1958. The Sri Lankan Constitution, the Bangladesh Constitution. The question is, once we have this miracle, which has surrendered power to various processes and institutions, how do we work it? Therefore, this is, forgive me for saying it again, is a ridiculous idea. The second pertains to the role of the judiciary. The judiciary is an important part of what I've called somewhere value accountability. It's a very complicated process. The judiciary is under great strain. But what it provides to our Constitution, silences an earlier question, is value accountability of the kind that is very difficult for the judiciary with all the limitations that Madan has just mentioned. But the judiciary is not a substitute for either governance or democracy. If they overstate their case, the people of India will lose faith in it. That has not happened so far. The third question I will address is the question of activism. We are not a homogeneous society that one government can pull up whatever it can. We are the greatest experiment in multilingual, multicultural, multi-religious, it's a civilization state the world has ever known. And activism is not a homogeneous idea. As I had indicated earlier, there are various processes where it takes place. Various processes to get accountability, to counter corruption, to counter arbitrariness, to counter violence. This is not a homogeneous idea. And people's activism by itself cannot be homogeneous. It attracts a huge number of institutions and processes. Thank you.
No, I just want to add about political community. You know, in December 2019, when the CAA was passed, I mean, among others, I was sitting at home very despondent. Who's going to answer? Civil society has been wrecked. Opposition is in a minority. And suddenly we saw what Rajeev has called a political miracle. There were these hundreds of students on the street with one flag in one hand and the Constitution in the other. And for the first time, believe me, the Constitution became a politically accessible public document because they were reading out the preamble openly. They had photographs of Ambedkar and of Bhagat Singh and of Gandhi, and they were singing the national anthem. Now, this is an instance of what is called leaderless movements across the world, and last when counted, there were 60 such movements in 60 countries, and it started off with France with the yellow vest. They assemble, it's all done by WhatsApp, and they attack the government for taxation or for incompetent administration and so on and so forth, and then they disappear. So they have no political program. So they do not believe in mobilizing the people. It's a bit of what the revolutionary terrorists did. They'd arise and commit an act of violence and then disappear into the underground. There's no attempt at mobilizing. So it's not the ideal, but it is an expression of spontaneity, protest. And I think it was effective. And if the pandemic hadn't broken down, it probably would have gone to its in a length, and if the riots had not broken out, if they had not been masterminded, which we all know they were. As for AI, you know, you have to understand what is political must be contested. And this constitution is the result of contestation, compromise, but also agreement. It's the outcome of political mobilization. It is a political document. Now, all attempts to reduce democracy to governance worry me because governance is not a political. Who doesn't want good governance? Governance is an administrative concept. The police is an administrative concept. The general rules for a society to live in amity, there is more than governance. You need rules where people belonging to different persuasions can live together in some peace and amity, if not harmony. And that is always contested. You must be always ready for contestation. So this whole idea of a constitution being created by AI for a new people will have no self-ownership. It'll be an alien document. So please think twice before the suggestion, because constitutions are political. They represent the aspirations of the people. In India, they have. In colonies, constitutions have not survived, other colonies, because the imperial power gave them the constitution, or at least subjected them to approval. So you have to appreciate what the power of public political movements can do.
Thank you.
What did Praveen ask?
The way in which the separation has or has not taken place. There are a number of instances where public functionaries have been seen performing religious duties together and so on. I think these are diminishing the ideal that was set in the Constitution. I think what we have agreed upon, and this is something that emerges, is that this Constitution is of course a living document. This is, if you take a political generation as being of 20 years, we are in the 4th generation which is applying this Constitution, which is conscious of the many infractions, the suborning, as I called it, in various areas. But the consensus seems to be that we have a good document, a miracle, as Rajeev says, and I think miracles come once in a lifetime. We shouldn't test our luck too often, and so we stick with it. May I ask the director, Dr. Srivastav, to come in?
We just heard the eminent panelists, on functioning of our constitution in the last 75 years and on the constitutional morality. They brought out several issues, problems, but the fact remains that the constitution has worked for 75 years. We have been a united country. There are shortcomings, no doubt. But through this democratic process, through deliberation, discussion, etc., this can certainly be sorted out in years ahead. Two things before I really propose of thanks to the panelists is two points I just wanted to bring to their notice for consideration. During their deliberation, they brought out the role of the governors, saying that those offices are being misused, they have been politicized. I was just wondering, Supreme Court has been laying rules, guidelines for appointment of various functionaries like CBI director, like Chief Vigilance Commissioner. Even in case of election commissioner, they laid certain guidelines. Why can't Supreme Court also think of laying down some rules, some guidelines, even for the appointment of governors? Because that position is so very important, as been brought out during the course of deliberation. The second thing which I would like to bring to your notice is that, as Justice Madan Lokur was mentioning, that whatever order Supreme Court passes, or any court passes for that matter, unless that order is implemented very sincerely with kind of ownership and involvement by the bureaucracy, it can never succeed. There is no examination as to what are the constraints under which the civil bureaucracy is working today. Let us not confuse the political executive with civil executive. The civil executive is under tremendous pressures, tremendous constraints, and there is no protection. As a result, what is happening is that they have all really withdrawn, and that is why we are seeing all kinds of problems in our civic administration. So perhaps Professor Vohra, we can have another discussion on these issues, because that is very vital, because I personally feel that unless the civil bureaucracy works efficiently and owns responsibility, the governance of the country can never improve. Ladies and gentlemen, on behalf of India International Central, I profusely thank Shri N.N. Vohra and all the three eminent panelists for sparing their time and giving, apprising us about their views and thoughts, and we will be looking forward to their participation in more programs at IISc in years ahead. My special thanks to Professor Aurora, because he is the one who has been leading a working group in IISc on federalism and democracy, and under that, a series of discussions, seminars, programs are taking place. And finally, we'll be able to bring out some very nice volume on this particularly important subject. And I am really very, very thankful to Professor Aurora for sparing his time, so much, for IISc. And I thank all of you, ladies and gentlemen, for your patience and for your gracious presence. Thank you very much.